What if I told you that you could discharge debt without court just by sending the right letters in the right order and at the right time? In this video, I'll break down how to build administrative paper trail strong enough to challenge debt and stop collection and protect yourself legally, even if you never step foot in the courtroom. Now, before we dive in this video, I've studied administrative remedy, consumer law, contract enforcement, and I'm going to show you how paper, not panic, gives you the power. I'm going to be talking about the 5 steps you must take in order to properly discharge debt administratively. Now, what is administrative process? Okay, it is a private process that I'm going to talk about in order to enforce any of your negotiable instruments. All right, now before we dive into that, make sure to hit the like button. Make sure to hit the subscribe button. You do this not only helps me, but it's going to help you because this is going to push it on the algorithm and this awareness will be put out there. One of the key things that I am big on is financial awareness and financial truth. I believe that financial awareness and financial truth will bring you closer to financial freedom than anything else. Okay, so a couple of things we want to lay down. Okay, this is not legal advice. This is not financial advice. Make sure you do your due diligence. Don't take everything that I say for face value. Make sure you research what it is that I'm putting here. Okay, because again, the stuff I'm going to talk about is so truth-based that I don't care if you don't believe me here. Okay, but go look it up, because when you look it up, you'll find that things align. Okay. Now, I want to speak to my current subscribers. Thank you guys for all the love and support. Y'all went crazy on my last 2 videos. Thank you guys for all the love and support. Remember to hit that like button. Now, when I say that, I'm gonna show you how to be able to discharge debt using paper and not panic. And about the aspect of you gaining power from understanding this process, here's the key thing that people struggle with when it comes to discharging debt. They think that it's about that initial negotiable instrument. They think it's about the bill of exchange. They think it's about the coupon. They think it's about a form. They think it's about you just sending in something and they're going to discharge it just because you sent in the proper forms. But the thing is if you understand what tender is, if you understand what a negotiable instrument is, then you can put it together, but they will manipulate you into thinking that what you're doing is wrong. They're going to manipulate you into thinking that saying that what you are doing is fraudulent. They're going to manipulate you and push back. So what I'm going to be talking about is how to be able to take them through a private process to where now you create the contract and now they must perform, and their non-performance is a violation. You dig me? Their dishonor is a violation. So if you send a negotiable instrument, if you send a tender, if you send an unconditional offer of money, if you send a unconditional performance, they must now adhere to it. Okay? So what we're going to be talking about in this video is why the administrative process works. We're going to be talking about the key laws that give this legal merit. We're going to talk about that step-by-step administrative paper trail, which is a 5-step process. Okay? It's a 5-step process. It's not a 1-step process, one letter, and hope that they're going to do it. We're going to be talking about a 5-step process that nobody is talking about. Okay. We're going to talk about how to make sure that it's properly organized. Okay. And we're going to talk about what this 5-step process, what this 5-step paper trail will do and can do for you as it pertains to debt discharge. Okay. Now, make sure you stay all the way to the end because this is going to be an absolute banger. This is going to fill in the gaps. The things that people say, you know what, I want to get on the phone with you, or I want to join your mentorship. If you understand this concept, then you won't need mentorship. But I totally get it. If this is the confirmation to say, well, Nicholas knows what he's talking about, let me go ahead and lock arms with him, by all means, do what you got to do. The link is in the description. But if you really take understanding and overstanding of everything I'm talking about, I guarantee all it takes is just a little bit of a due diligence after the fact. All it takes, especially for my people who's been studying this, to say, damn, he really just connected the dots. That's all it takes. And if you're here energetically, if you are listening and not hearing, if you are taking notes and writing down these concepts, I guarantee you, you have more confidence when doing the administrative process, when discharging debt, and you'll be able to not only be able to settle stuff before court. You may never need to go to court, but even if you do, this right here, I don't think anybody will go against this 5-step process. So let's dive into it. I've done yapped enough. Now, what is the administrative process, okay, and why does it work? Let's talk about the aspect that court is something that is public, costly, and reactive, okay? A lot of times we are reacting to a court summons or something like that. And, you know, typically it's they do give you time, but it is last minute, okay? Find out in 2 months, you have to show up to court, okay? And that's just the reality. It's a procedure, okay? So with the administrative process, it is something that is private, written, and proactive versus reactive. So what I'm going to be telling you guys is something of you taking the initiative first. We don't wait around for the debt collector to put us in a position of where they have the advantage. No, we initiate our offense, okay? We don't play defense. I mean, so when you do the administrative process, the law assumes silence equaling agreements if unchallenged. So when you are challenging the company on the validity of the debt, when you're challenging the truths, okay, and that goes unrebutted, or they decide not to respond, which a lot of people say, well, what if the company ignores me? That right there is an agreement, okay? So if somebody doesn't respond, oh, you agree. Or in other words, you know you're wrong. Because if I'm saying you're wrong in the letter and you cannot respond and tell me why you wasn't wrong, you are trying to delay the inevitable. But here's where we go wrong. We don't understand that silence means agreement. Silence is acquiesce. And acquiesce is literally what you want. You want them to acquiesce. When someone says, oh, they ignore me, I say, perfect. What did you do after that? Oh, I just sent them an email. I called them. You don't want to do that. Because if they don't respond properly, you gain standing and evidence. Okay? And when I say standing and evidence, you put yourself in a position of where you now hold the keys. The ball is in your court. Okay? And here's the key thing that I want you guys to get. Okay? This is not only for my subscribers, but this is for my mentees. You know what I mean? If you're my mentee and you watch my video, this one is for you. If it is not written, it didn't happen, okay? And if it is unrebutted, it becomes truth, all right? An email, a phone call, I don't care if they recorded, if you recorded, whatever the case may be, write your letters, okay? Write your complaints, document it, and send it to them. Have them now respond back to you with their lies written. Because they'll tell you anything over the phone. And if you believe it, you don't even have record of their lies. You're just going to say, oh, I spoke to X, Y, and Z and they told me this. Or I know they're violating me. So why don't you put it on paper and tell them that? What did they violate you on? Okay? Really? If you're going to say they violated you, then you should be able to put that on paper and tell them how they violated you and their consequences for violating you. But you see, you're hoping that they will tell you that they violated you. No, that's not going to be the case. Remember, we're playing offense. All right. Now, a couple of laws I want to pull up, okay, because I pull up these laws specifically for the new people, because I know my people that watch me all the time, they know these laws already. They are doing their due diligence. They are the ones that are taking everything that I'm saying and will do the research, okay? So I'm going to go through these relatively quickly, okay? And I like to do this because again, this just reinforces. I like to keep repeating these laws because a lot of times people will come and they'll say, and especially when I first started the industry, I had to go in the comment section and bring up these laws. And it's just like, no, I'll bring, if I have to bring them up every time, I will, because until someone, comes back and says, you know what, boom, we got it, then I'm going to keep doing it. Okay? Because this is for my new people. So if you guys know this, I get it. We're going to go through it again. All right. So right off the bat, the first thing I want to talk about is 15 USC 1692G, which gives you the ability to validate debts. So company says that you cannot validate debt. They are violating your rights. But more importantly, not only under 15 USC 1692G, you can go back to the subchapter V and see the different violations that a debt collector will do to you when you are exercising this validation process. Okay. So one of the key things is the acquisition of location information. If a company tries to repossess your vehicle or some third-party company gets your information, that is a direct violation of 15 U.S.C. 1692B, because only you should be giving people your information. They should be notifying you before they give somebody your information. Okay, and give you the opportunity to opt out. Then we dive into the communication, how a debt collector and you should be communicating with each other. So if you have a question about communication, you want to see the law behind that, you come to 15 U.S.C. 1692C, C for communication. You know what I mean? So tap in with communication with debt collectors. Then we talk about the aspect of harassment or abuse, okay, which breaks down what harassment is. Okay, so the use of threat of violence or other criminal means to harm the physical person's reputation or property of any person. Okay. The use of obscene and profane language. The natural consequence is which to abuse the hearer or reader. All right, just got a little tongue-tied. Okay. The publication of list of consumers who allegedly refuse to pay debts. Okay. Except to a consumer reporting agencies. Okay, advertisements for sale of any debt to coerce payment of debts. Okay, causing a telephone to ring or engaging any person in telephone conversation repeatedly, continuously, with intent to annoy, abuse, or harass any person called at that number. The placement of telephone calls without meaningful disclosures or caller's identity. That's under harassment. Unfair practices. Validation of debts. What to do when it's multiple debts, legal actions by debt collectors, furnishing deceptive forms, furnishing false and misleading forms, civil liability, what they are liable to if they violate any of these rights. And it says right here, $1,000. Okay. So, and also actual damage as well. Okay. Whether it's money spent, things that are lost. All right, so this under the 15 U.S.C. 1692G. You dig me? Then we go to the aspect of defenses and claims against recoupment, which means that you can defend yourself against a company that decides to not prove their standing. Okay, decides to not to prove the legitimacy of their claims. So in a letter, when you ask a company to prove their claims and they do not do that, then you have rights to defend yourself under it. Okay. Some of the key things is if you contracted to something under duress, lack of legal capacity, illegality of the transaction, okay, it says it nullifies the obligation of the obligor. And then also fraud induced the obligor to sign the instrument. Long story short, they persuaded you to sign the instrument or the loan agreement, making you think that it was something it wasn't. Okay, that is also something you can defend yourself against. Another thing I want to talk about is tender. Tender is to unconditionally offer money or performance to meet an obligation. One of their biggest arguments is that you're supposed to give me legal tender. Well, what is legal tender? They're going to say it's the Federal Reserve note, the dollar bill, but that's not what tender is. Tender is to unconditionally offer money or performance to meet an obligation. Okay, then we're going to go to the aspect of UCC 3-603. It says that if a tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge to the extent of the amount of tender of the obligation of the endorser or accommodating party having a right of recourse with respect to the obligation which the tender relates. Long story short, it says it right here. You know what I mean? Refuse me, my baby, and it's discharge. Sometimes some of us think that it's our forms and it's our documents that's going to get the debt discharged. It's their actions that discharge the debts already. Okay? Then we could talk about UCC 1-308, which is essentially saying this is when you sign something, you put without prejudice, you put under protest. Okay? You put UCC 1-308, which essentially says that, hey, look, I do not waive my rights under this contract. Okay. When I'm talking about rights, I'm talking about all of my rights under the UCC, all my rights under the Constitution, all my rights under contract law, because they'll try to say that you a contractor or you agreed to do something. And sometimes we unknowingly agree to waive our rights. Okay. So that should protect you. Then we could talk about the aspect of contract law, which is when you understand contract law, it's about the aspect of offer, acceptance, full disclosure equals a lawful agreement. Okay, so long story short, when somebody sends you an offer, okay, a contract requires a clear offer from one party and a definite acceptance by the other. Okay. Another thing, consideration. Each party must provide something of value in exchange for the other party's promise, which is super important to understand, because consideration in this case, as it pertains to loan, is the money, the lawful money that you signed for. Okay, so if you signed for a $40,000 car, you didn't sign for the car, you signed for the $40,000. Okay, they then wired the $40,000 to the dealer's bank account on the premise of your signature. Well, we're not about to dive down that. Okay, offer plus acceptance equals full disclosure. It must reach these key points in order for this to be a lawful agreement. Okay, disclosure is another key thing. Anything, you should have full capacity under the contract. This should have full legality. Okay, so contract law has to meet these principles in order for that contract to be valid. Now we're playing a contract game. Also at the same time, what is this right here? Tender is an unconditional offer of money. So you just started a contract when you start this process that I'm about to talk about. When you start this administrative process, when you send a negotiable instrument, which is UCC 3-04. Negotiable instrument means an unconditional promise or order to pay a fixed amount of money. Okay? So that's the same exact thing as a tender. Okay, so when you understand this, okay, the thing is once you create that contract, they are required to respond point for point, or that is dishonor. The UCC 3-505. On the UCC 3-505. Okay, so if they dishonor you, they should be giving you reasons as to why they refused. Okay, so, and this is under the negotiable instruments, or Article 3 of the Uniform Commercial Code, negotiable instruments. Okay, you can even dive into Article 9 to learn about secure transactions, which is most credit transactions. But when you know these laws here and you take the time to review these, it makes the conversation much sweeter. Now let's move on, because we talked a lot about that. Let's talk about this exact process. Now, before we dive into this process, we 19 minutes in. Go ahead and click the like button. Go ahead and hit the subscribe button if you haven't already. Okay, thank you guys once again. Now, I'm going to talk about 1, 2, 3, 4, 5 letters. So make sure you take out your notebook and notepad. All of these letters that I'm about to mention is something that you can literally write down and go look up yourself. Okay? Someone will say, well, why don't you just show the letter? I mean, I don't want you to use my letters and templates. I don't want just anybody and everybody to use my letters and templates. Okay? I want you guys to actually do the due diligence and learn what these processes are. And then when you learn these processes, you'll know exactly how to make these letters. It's not going to be a rocket science. Okay? And plus, I've already done it. For time's sakes, I'm not going to pull everything up. So the first things first, a debt validation letter. You send a debt validation letter and you want to demand for the original contract, accounting, and lawful authority. And you want to make sure to send this certified. That'll be step 1. Okay? You can also include a conditional acceptance letter with that, or as a matter of fact, and let's just say you are initially challenging the debt, you can start with the debt validation letter, wait for their response, for them to either disprove or whatever the case may be. Then you can send the conditional acceptance, or you can put the conditional acceptance and the debt validation together. So what is the conditional acceptance? Once you understand this, you can't kind of be strategic based on your situation. Okay, bet. Let's just say they're able to prove standing or give you all the documents under the validation of debt. You then want to go and say, hey, I'm willing to pay if you can prove. Okay, it restates your demands, adds conditions, and shifts the burden of proof onto them. Now it's not now you just created a contract where they must perform by providing these disclosures. Perform by proving their claims. If they cannot prove their claims, then they should not expect you to pay. Because if you are maneuvering in honor, then you should be able to prove everything that I'm challenging. It's like if someone says, well, you owe me $1,000. Okay, show me where you gave me $1,000 and I didn't give it to you. Okay, well, I'm gonna show you. I sent it to you on Cash App and I haven't gotten the Cash App back. Right? People think that this doesn't apply just because they're a big company. No, it's the same exact thing. That's conditional acceptance. Then we dive into the affidavit of truth. What is an affidavit of truth? It's a sworn statement of facts. Hey, this is what I know to be true. And it forces rebuttal under penalty of perjury. So if you do not rebut point for point, then everything stands in truth. So that is the important aspect of an affidavit of truth. An affidavit of truth will break it down exactly what you know, and they're supposed to literally prove you wrong. They're supposed to disprove your truth before they can collect, before they can enforce their contract. They must do this stuff, because if you say a contract is not valid and they don't respond to that point, then they just told you or accepted or acquiesced or agreed to the contract not being valid. So you put this together so that they cannot not respond to you. It kind of forces them to do it. Then you want to dive into the notice of fault and opportunity to cure. So if you send this and let's just say 30 days, some people 10 to 15 days if you're going to be on top of it, when you do not get a response, you send them a notice of fault, which is literally saying, hey, you are at fault. You have dishonored me by not responding, but I'm going to give you a second opportunity to cure your fault by literally just providing that proof of claim or coming with an actual response that goes along with my letters. Their next response should not be a debt collection letter. Their next response should not miss any points at all. Because if it does, then they are at fault. Okay? And what comes after fault? Default. Okay? If you get if you send step 1, step 2, step 3, then you get to step 4 and they still do not comply, oh, my baby, you just hurting yourself. You have defaulted. Notice of fault and dishonor, which establishes your unrebutted claim, and it creates a legal record of acceptance by silence. This right here, you take these 5 steps, you take these 5 letters, you do this over a period of 45 to about 90 days, then you pretty much will have created a case. Okay. You can also include the aspect of a tender of payment, money order, coupon, bond to fulfill your duty. Okay. So they can't say you did not fulfill it, because part of you asking them and shifting the burden of proof, they have to prove that your unconditional offer isn't something that you can use to pay or satisfy the contract. Okay. So here's how you're going to keep this organized. You're going to send everything certified mail only. And if you do send a tender of payment, you can also do registered. But I will say certified is much cheaper, and all you need is that paper trail. Number 2, you're going to keep copies of every letter sent and every letter that you receive. Okay? You want to log each step in a journal, dates, tracking numbers, their responses. You want to put that in a folder. Number 4, you want to create a private administrative record that can be used in courts or arbitration. So you want to put all of this together and for safekeeping if they try to sue you or when you are ready to sue them. Okay? If you ever need to defend yourself, the paper will speak louder than you ever could. So guess what? There's no panic if you do this the right way. There's no panic if they try to default, because you've already exercised your process. You already mediated it, and you already proved them wrong. You already proved their silence. So if you already proved them wrong, you already proved their silence, I can be silent now. Okay? Now, obviously, I could tell you these processes. You can send these letters, this, that, and the third. But if you don't understand what these letters mean and what their goal and sole purpose is, then when you get into court, I don't care if you did all of this. It's not, you can't just be silent. Okay, Because if they ask you, oh, you don't know what you're talking about, then they're going to take advantage of that. Okay? Here's what the paper trail can do for you. It can stop collections or lawsuits. Okay? When you start this administrative process, they must cease collection. Okay? And then also at the same time, if they try to sue you, you bring this evidence up in court. Hey, Your Honor, I tried to communicate with them and ask them for proofs, and they couldn't provide it to me. Number 2, it's going to establish contractual dishonor. Once they dishonor you, then their contract is null and void. Okay? So whatever they're going to try to enforce, it doesn't matter because they had a duty to fulfill because you guys contracted under the Truth in Lending Act, under contract law. There are some foundations that should be put in place, and one of the key things is disclosures. Number 3, this can be used in small claims court, arbitration, or even private trust enforcement. Okay? You can prove that you sought remedy and were ignored. That is within itself is a violation that is unacceptable. Okay? Because remember, these companies have a duty. All right? Then we want to talk about how this can strengthen your claim for discharge or settlement. Okay? You can get discharge debt or you can settle the debt. Paying lower, or you can sue them. Have them pay you. Okay? I'm telling you what you can do. I'm not giving you advice. You do your due diligence and make sure you fully understand these concepts. If you don't understand these concepts, then it doesn't matter what I say here if you're not willing to do your due diligence. So when you build a strong administrative file, you are no longer begging, you are actually asserting. Stop hoping. Initiate. Be assertive. Okay? Assert your rights. Because that's the only way you're going to get remedy. Not by you just sending this out and hoping it will work. It's not going to work unless you are willing to assert your rights. Part of you asserting your rights is going to court. Speaking for yourself. Okay? If you're not going to do that, you're still going off of hope. Okay? You take a company through this 5-step process, you have evidence to take them to court. You have evidence to stop their lawsuits. You have evidence to stop collections. The aspect of what that remedy could look like for you could be entirely different. It could be them stopping collection. It could be them not bothering you. It could be them settling and giving you money. It could be them removing this off your credit report. It could be them stopping with the phone calls, right? Stopping with the letters, stopping their lawsuits. So remedy can look very different. This is why you have to be clear in what you want. And this is what you'll put in your paper. You put it in your paper, then you don't even have to explain what it is that you want. You've already put, hey, if you don't do this, this is what I want. Simple. Now, they win when you react emotionally. You win when you move strategically. And best weapon is a paper trail that they cannot ignore. Remember, use the process, use the affidavit of truth, use these laws to your advantage. Learn them. The true power is in the learning. The true power is in the knowledge. It's not in knowing the process, because they follow procedures. And this is exactly why they lose to someone that is knowledgeable. Okay? So if you've gotten this far, thank you guys for watching this video. If you want that full administrative remedy letter pack, it's in the Complete Debt Guide down below. Go ahead and click the link. Tap into the Complete Debt Guide. Okay? Number 2, if you want to work with me one-on-one, only for people that are serious about their situation and are ready to invest in themselves. Okay? You're not going to get on the phone with me and have a free conversation. Trust and believe. Number 3, follow me on Instagram at biz.nick. If you want to be notified on my YouTube videos, you want to be notified of and understand administrative remedy, I do short form content there. But more importantly, just tap in with me. All right. Lastly, have you ever sent letters and got silence back? That's where your evidence begins. Drop a comment down below. Tell me about your situation. Tell other people about your situation. Drop any laws, other information that you are also interested in learning more about if you want me to break down even more. And then lastly, hit the like button, subscribe, turn on the post notifications so that you get an update every time I drop a video. Happy Monday. And if you've gotten this far, comment the word discharge, and I'll see you in the next one. Ha!